Hey everyone, sorry we're late. It had something to do with Bruce's cans.
That's accurate.
Yeah.
Not wrong.
I feel I need to put in a little disclaimer here because of the person that we're talking about in this stream. We're reading a public document filed publicly and obtained by a member of the public. This is in no way, shape, or form harassment. Laura Owens, the subject of today's stream, is not someone I have ever communicated with or ever have any desire to. And if she's here now, she should leave because I would like her to leave me alone. So, anything that I say here is a commentary on the publicly filed documents. They are my opinions. This is not a love letter to Laura. So again, if she doesn't like this kind of commentary, she should leave. But I mean, she's running out of people to sue at this point. So I got to think I'm higher on the list than I used to be.
Uh-oh.
So, all right. This is from the fee motion, the attorney fees and costs that Omar filed on Mike's behalf. Omar, of course, being Mike's attorney in the DVRO case out in California. And we're not going to be able to get to all of it right now because it's the middle of my workday. So I had to do this during my break. So we're going to read one part of it and then I'll come back tonight and we'll go through the rest. Let me pull up the thing that I had. We're going to go over this. It was an exhibit on this and it's her, let's see, ex parte application for extension of time to file opening brief. And she says a lot in here. She says a lot, not a lot of true things, but she says a lot in here. And so we're going to go through that. I don't know if you've actually read this yet, Bruce.
I have been skimming the documents. That's why
Right.
I was late to getting in backstage because I was
Okay.
enraptured by these documents.
Yeah. What does that see you next Tuesday doing now? Well, this is a an exhibit of the Mike's fee motion, but it's Laura's. She's asking for an extension to file her appeal brief, basically.
Yeah. Luckily, it's Wednesday.
Wait, why is that lucky?
Because it's not Tuesday.
Oh, sorry. I did not catch that.
I'm still drinking coffee, Lauren. Give me a break.
I mean, it is 11. We should be awake by now, right?
It's 10 here.
Oh, I forgot you were an hour behind. Okay. Anyways. So this is Laura's, asking the court to give her an extension to file her appeal brief, which they did grant until, what is it, end of June? I think. They did grant this request for an extension. Okay,
June 27th, it says right there.
Right. So they did grant that, but I haven't read through this document. And this document, she probably didn't need to do all this in this document, but we know that she likes to overplay her hand, which is, usually empty anyways. But she goes through a lot of weird Karen-like discussion here where she probably could have just honestly just been like, I need an extension for XYZ reason. Please grant me one. And they would have granted it. Apparently that's like very typical. So she didn't need to do all this. This is just like weird soapbox, ranting, which is fine if you're doing it on medium.com. But for a court, it's just like, okay, well, I'm going to roast you for it, but all right.
Yeah, I mean, you want to make your case you want to play golf, right? You want to win your case with the fewest words possible.
Right. All right. Well, without further ado, this is what happened on November 5th, Laura's version. Okay. On November 5th, petitioner's request to renew a DVRO was dismissed for non-appearance on a record that does not accurately reflect what occurred that morning. Well, Bruce and I were both there that morning, and I would say it's pretty accurate, but all right. Since that dismissal, petitioner has actively sought appellate representation. With what money? In the weeks immediately preceding this filing, she filed this recently. What was the date on this? Let me look at the bottom. April 23rd. Okay, so as recently as last month, she was seeking representation from lawyers. I don't know if she's seeking private attorneys or what.
That's 2 weeks ago.
Yeah, right. I don't know if she's seeking private attorneys or what, but she somehow found the money to get another private attorney or criminal case. She can't pay Clayton or anyone that she's in debt to, but she can hire attorneys to continue carrying out abuse of the legal system. That's fine. I don't know how that's happening, but anyways, since that dismissal, she has actively sought appellate representation. In the weeks immediately preceding this filing, 2 sources of legal counsel who had each conducted substantive reviews of this matter declined to represent her.
Oh,
I would
no.
too. Not
They
for.
did?
I would decline to represent her too because I think she's nuts. But
Why would they do that?
Also, she's broke, so like, that's not going to help. Not because the appeal lacks merit, but because the facts underlying it are not in the official record. So we're going to hear her version of events, and she's saying this is why attorneys don't want to represent her in this appeal, and that's going to be interesting. Both stated they would reconsider once that deficiency is corrected. So she probably then said to them, you know, here's a bunch of bullshit that happened, and Mike did this, Mike did that, and then they're like, okay, we'll get the record corrected, and we'll take another look. The 60 days petitioner requests are what is needed to correct that record, secure the representation. These reviewers have confirmed this appeal warrants. They said no, so I don't know how they confirmed that the appeal warrants that.
Yeah. Lauren, do you think these lawyers saying, well, we can't represent you if the record isn't correct, do you think that's their analogy of it's not you, it's me? We have to break up. Is that what's going on?
It could be. It could be. They're going to have to let her down gently the second time, too, or she'll file a bar complaint.
Right.
But, you know, also, we have no idea if that's what they actually said, if that's all they said, because she lies about everything. So, and prepare a brief that accurately presents what this court is being asked to decide. The record deficiency is traceable to a specific and documented procedural problem. On December 3rd, that's 2 days before the hearing, petitioner Laura filed a motion to correct and augment the record in the San Francisco Superior Court. The motion was never contested and was never ruled upon. Oh no, December 3rd was a month after. Never mind. That wasn't before. It was after. It was like, that doesn't make sense. That motion was never contested and was never ruled upon. The following day, petitioner filed her notice of appeal, which under settled California law divested the trial court of jurisdiction over the pending motion. Okay. The motion has never been adjudicated in any court. All right. Kind of sounds like you might be doing it wrong, but whatever. As a result, the facts underlying this appeal are not before this court. The official record, 5 pages documenting a 4-minute proceeding, reflects only that petitioner did not appear and that the matter was dismissed. It contains no reference to the 2 written pre-hearing notifications petitioner sent the court advising of a life-threatening medical emergency. The court's written acknowledgments of those notifications received before the hearing began, the medical documentation she submitted, her offer of HIPAA authorization that no one accepted, the ADA accommodation requests she raised and which were denied, the ex parte communications between court staff and respondents' counsel from which she was entirely excluded the day before the hearing, or her formal written refusal to waive her statutory right to an official court reporter. That, I mean, she didn't have to because they had a court reporter. A refusal that, under the court's own written directive, required the matter to be continued. Huh? They had a court reporter. And she's going to get into more detail on a lot of this stuff in a second, but this stuff like the medical documentation, the offer of HIPAA authorization, she didn't show up. She needed to show up. And also with this is going to be a problem for her when she actually tries to file the appeal. With the previous hearing that got continued, she was horse jumping when she said that she was in a life-threatening condition. And she was at that horse jumping show the days that she was supposed to be in court, saying that she was basically like on her deathbed. And then there's an affidavit that we're not going to read right now because I have limited time this afternoon, but there's an affidavit from somebody who was there attesting to that. So, and Bruce texted me about that. Fake Laura Owens, thank you for the $5. Just when you think I can't get any crazier, I prove you wrong. Well, she's always keeping things interesting, I guess. Let me see. Jack says, I don't think those lawyers said that at all. I agree.
Right.
What's up?
Oh, it says the ADA accommodation requests you raised, which were denied. Isn't that the reason for the first continuance?
Yes.
An ADA accommodation? So there was at least one ADA accommodation request that was accepted and not denied.
Right.
But she leaves that out.
She does like to leave things out. So, all right, let's see.
Anyway.
Okay, that record cannot support meaningful appellate review. An opening brief filed on it would misrepresent the proceeding it purports to address. So she's saying, I can't file my brief because it's addressing a record that's incorrect, I guess. 60 days to correct the record, blah, blah, blah. They granted this request, by the way, so it doesn't matter.
Yeah.
But that doesn't mean that anything that she said here is like definitely the truth. It just means like it's normal for them to grant her an extension. It's like not rocket science. I don't know why Laura did all this. Actually, I do, but it's not important.
So how does correcting the record work? She's got to file something before the end of next month, and
Actually don't. I don't know for certain, but I don't want to give her any ideas. So.
No, I just mean the process, like the legal process. She's supposed to file something before the end of next month, and then they would approve or deny it. And if they approve it, she has a better appeal position. Is that the idea?
Yeah, I think she's doing it wrong, though.
Oh,
is the thing.
I'm not a process expert on this.
Yeah. Malin says, who wrote this motion? Laura did. And probably David, but Laura. You know, we'll never know for sure if David wrote this, but Laura definitely had a hand in it. So, all right. He likes to help. Okay. The record versus what actually occurred. Okay. She's talking about the official record. The reporter's transcript on appeal spans 5 pages and records the following. At 9:26, the court called the case, noted petitioner's absence, appointed a privately retained reporter pro tempore because no official reporter was available, dismissed the matter for non-appearance, permitted respondents' counsel to reserve on attorney's fees, and adjourned. The entire proceeding lasted approximately 4 minutes. Yeah, we were not in there for very long that time.
No. I had a whole notebook, and I took 1 page of notes, and then I turned the page and wrote 1 more note, and we were done.
Yep. Yeah. And then everyone clapped.
Yeah. Like,
that actually happened, though. People say, and then everyone clapped to be sarcastic. No, everyone clapped.
They did. I was aghast. I'm like, I don't know if the judge is going to like this.
I did not clap because I'm afraid of pissing off judges. So
I know. Also, I made sure not to sit next to you, Lauren, because I knew if we sat next to each other, we would probably just like start cracking each other up, and that would have been a mistake. No good at all. So I sat on the other side of the room.
All right. B, November 4th, the day before the DVRO renewal hearing. So she's now going to tell us what happened in her view, which is going to be interesting. At 10:05 on November 4th, it was the day before, the court emailed all parties that there was a high chance no official court reporter would be available the following day, and that because this was a DVRO trial, the matter would need to be continued if any party declined to waive. Petitioner relied on that representation. She did not waive. Okay. What followed was a series of communications from which she was entirely excluded. She wasn't, by the way. At 10:10 a.m., 5 minutes after the court's all parties emails, respondents' counsel emailed the court's department directly without petitioner to inquire about securing a private reporter. That discussion continued throughout the afternoon. At 3:32 p.m., court staff asked whether the proposed reporter was certified. At 3:42, respondents' counsel confirmed one had been secured. At 4:08, court staff asked for her name and license number. Petitioner was not copied on any of it. And here's why there's a problem with that statement right there. She was added to the chain at 4:40 p.m., meaning that she was added and had access to all of these emails above, which is why she's detailing it with timestamps, because she was in fact included. So
she was only excluded until she wasn't.
Right. So she got all the information. And she was added to the chain at 4:40 p.m. after the reporter had been identified and approved through a process conducted entirely between one party's counsel and the court. Right. So one party pays for the court reporter. You don't need to have both parties paying for a court reporter. That's how that works. If they don't have one already, appointed, if they're not worried that the court's not going to have a court reporter, one party can hire one. It's not like rocket science again. Okay. Upon receiving that communication, so you did in fact receive the communication, petitioner immediately filed a formal written objection invoking government code section whatever, documented her exclusion. Imagine emailing the court documenting your exclusion from a thread that they have included you on. And explicitly declined to waive her statutory right to an official reporter. That is an official licensed reporter. Okay. Under Rule 2, whatever, the court was required to reflect on the record whether each party waived or refused to waive. The mini minutes are silent on the subject entirely. So she did, it doesn't matter. She refused to waive, but they had a court reporter is the thing. Like, correct. None of that means anything.
Yeah, the court reporter was part of the hearing that day. So it is documented.
Right.
Now, this a particular email might not be Like, I don't know, the minutes aren't going to document, I went to the restroom and then there was an email and then I had some water. I mean, it's
Mhm.
not, she's looking for like documentation of her entire life here.
Right. MG Law says the discussions about a court reporter were not regarding any facts or merits or the case, so it's not improper ex parte communication.
Yeah. Exactly. I think the problem is she finds things to complain about, but because she's not a lawyer with a bunch of experience, she doesn't understand how the process normally works. So if you gain experience in this job, you'll
Hi, Brad.
understand, oh, this is the way things work in the process. Like MG Law understands what you need to do versus what you don't need to do.
Mhm.
And she's just going with whatever she can think of to complain about.
Oh, whatever she can think of to complain about is exactly why so many people have been stuck in court for so many years. So. All right, let's see. At 5:08, the first moment petitioner had confirmation the hearing might proceed, her family purchased emergency last-minute air travel from Scottsdale, Arizona, where she currently resides, to San Francisco. I would ask again, with what money? For the following morning, she transmitted the confirmation to the court that evening. Okay, cool. So get on the plane. Let me just go back here real quick. The first moment she had confirmation the hearing might proceed, there was never a point where they said it was canceled. So the first moment you had notice that the court might proceed was whenever they set that November 5th date. So October 22nd was the first moment you had notice. Let's see. There was a high chance no official reporter would be available. Correct. So they didn't say we can't do the hearing. There's no court reporter.
That's not an absolute. If
Right.
it's a low probability that court will happen, and I am a litigant or
Right.
a petitioner or respondent in that case, even if there's a low chance court will happen, I will be there. Like, come on.
It's just like you obviously had to show up. She obviously had to show up, and she's just like being petty.
Like where I used to live in Oregon, if you got called to jury duty, there was a low chance you would end up on a jury, but you still had to go to jury duty.
Right. Also, the hearing was at 9. It was supposed to be at 9. I think it ran late, as far as I remember. I think we went in there at like 9:20 or 9:30. She's saying they purchased emergency last-minute air travel from Scottsdale, Arizona for that morning. The earliest flights aren't going out early enough for her to make it that morning.
Yeah, it'd be interesting to see that ticket. Is that some kind of red eye?
Yeah, if you well, she said that morning. I'm assuming there's a record of what flights were going out from Phoenix Airport that morning. But like I said, it doesn't matter because she couldn't have gotten there on time.
To leave or arrive? I mean,
to arrive on time. So like if she's leaving, even if the first flight goes out at like, say it goes out at 6, which is what happens at my airport. I don't know if there's flights that go out earlier than that. Other places probably maybe 5 o'clock or something.
Yeah.
She would still, have to get to the airport, collect her things, get transportation from the airport to the courthouse, possibly in morning traffic. There was just no way that was going to work out. She needed to be there at least the day before.
It's very hard.
Mm-hmm.
Yeah, we would need to see the flight logistics to do the math on that one.
So my guess is it doesn't matter if she had taken a flight that morning. She wouldn't have been able to show on time, and her case would have been dismissed because the judge was very clear about this. And she's, trying to say that she didn't know she had to be there when the court never told her not to be there. So it's just like none of this adds up. So whatever happened after that doesn't matter because she was not going to show. I mean, it might matter legally, but to me, it doesn't matter because I know she was never going to show up. So
Boots says flights leave at 6 a.m. out of Sky Harbor.
Right. You can't count on that to get you to the courthouse you'd have to be there before 9 o'clock.
And then I think Arizona's in December, it's on the same time zone as California.
Mm-hmm. Yeah.
Otherwise, you'd get an hour back, but I don't think.
Yeah, no, they were, well, actually, at certain times of the year, I think Arizona is an hour ahead.
Right. That's what I was.
Yeah.
Arizona's always so confusing figuring out the daylight savings time.
I don't even know. So, okay. Anyways, it's not like I'm sitting here opining over things that don't really matter because it doesn't matter. She didn't show up.
This is a good point in chat. We never saw a filing in the criminal case to leave the state.
We did the second time.
For the second hearing, but
yes.
Not the first?
Not the first.
Oh,
Correct.
I see.
Mhm.
So yeah, the first one. So she was always planning on zooming in on the first one.
Mhm.
Very good. Okay.
The court should issue a show cause and demand production of the plane ticket and proof she would arrive in time to appear in person or dumbass face sanctions.
Yeah.
Yeah.
So wait, 2 hour 40-minute flight from Phoenix to San Francisco. That's a long. I mean, it is a long distance.
Mhm.
Wow.
Yeah.
So yeah, that probably would not have arrived on
No.
time
Mm-mm.
after getting a cab and all that jazz.
Right. I mean, it was not a short ride.
Arizona's an hour ahead in December, so that's good. Okay.
Gotcha. Well, when there was not like it wasn't like the longest ride ever from the airport to get into town closer to where the courthouse is, but it wasn't like that short of a ride either. So you got to think, if it's 2 hours and 40 minutes, even if she leaves at 6, she would get there at what, 7:40?
That's
It's a little
chaos.
risky. You're counting on the plane not to be delayed at all, and then also you have to wait and get transportation. Yeah,
Yeah.
that's not responsible.
I mean, it's cutting it very close.
Right.
Which
Also, you have to assume that there was an actual seat assigned, like there was a seat available on that flight the night before. So I don't know, not a standby ticket, but an actual seat.
Yeah, and
Yeah.
I've been on plenty of flights where I had a ticket, I had a seat, and they got to de-ice the wings, or they got something with the engine, they got to get a new plane,
Mhm.
or the previous flight didn't arrive in time.
Right.
It's chaos. You could hit an accident on the highway in your cab and get delayed.
Right.
It's just not. It's an agent of chaos cutting it this close, like
Yeah.
they say in the
She wasn't taking this seriously.
Love Trap podcast,
Right.
Chaos Agent.
Okay. So, November 5th, the morning of the hearing, in the early morning hours, she suffered a sudden and severe medical emergency. She was vomiting blood and was transported to Honor Health Hospital's emergency department, where she was admitted for a procedure under anesthesia. So she got an extension because she was saying that she had a life-threatening condition and like she was about to have these issues. Why did they not do a procedure before then? Is my question. If you're bleeding, if you're vomiting blood, if you have gastrointestinal bleeding, they're not going to take chances with that and be like, well, we'll revisit it in like a month or so. No, that's not what's going on there. At 6:21 a.m., more than 3 hours before the matter was called, petitioner emailed the court and all counsel describing her condition, her hospital admission, and her physical inability to appear. Hold on. 6:21 a.m. Shouldn't she have been on the way to the airport like 2 hours before that? I mean, I guess I don't know when she started vomiting, but she submitted medical documentation and offered without what medical documentation? You got to okay, whatever. And offered without reservation to execute HIPAA authorizations permitting immediate independent verification by both the court and respondent's counsel. Again, we have to take her word for it, which is never a good idea. Court manager Francis Yokota replied, email received, thanks. Okay. At 6:53, she sent a second notification. She was being formally admitted. The procedure under anesthesia was proceeding. She was expecting to remain hospitalized overnight, and she requested a continuance. Court manager said, good morning, Miss Owens. Email received. Thanks. Yep. I mean, the court's not going to sit there and grieve with you about your medical issues. The court thus received written notice of a life-threatening medical emergency accompanied by medical documentation and an offer of HIPAA verification, and acknowledged it in writing twice before the matter was called. Did she think that people were going to be able to execute a HIPAA release and get the documents before 9 a.m.? That's not a thing. No continuance was considered.
Just log into our patient portal, Lauren. Come on.
Right, exactly.
We just need the password.
I think everyone has it at this point. The verification petitioner offered was never requested. The case was dismissed in 4 minutes. The reporter's transcript contains no reference to any of this. The case was first thing in the morning in business hours. So offering a HIPAA verification outside of business hours and not during the day, like before the hearing, they're not going to be able to do anything with that. It takes a while to execute these things. She would have to sign off on it. Omar would have to, or the court would have to send it to the office. The office would have to get to it in the order they've received these things and then send it back. That could take days, not minutes. So I don't really know what she was expecting there. But no, the hearing was first thing in the morning. They weren't going to be like, stop the hearing, and let's execute a HIPAA release, and then we'll decide what to do. Like, that's stupid. So constant victim mentality. That's what this is. Yeah. Correct. medical documentation because she was admitted. Hospital won't issue anything until after the care. That's probably true. Yeah.
Good point.
I've never come across a situation where somebody wanted medical documentation before they were released. So other than like a work note, but usually that's after, like, again, like she said, after.
I mean, can you imagine? They're like, okay, we're putting you under anesthesia. Here's the mask. Count down from 100. And she's like, 199. By the way, can you get me some medical documentation for my court case in California before I pass out? I mean, what is going on here?
I don't know. She's obviously fine because she's alive and relatively well compared to like dying. You know what I mean? So like, she's got some problems, like some health problems that she's documented over and over again, but like she's obviously alive and fine. So I don't really feel bad questioning this, especially given her history of medical fraud and also faking doctor's notes.
I feel like she relies on court documents, like her restraining orders that she gets on people, as sort of this proof of reality. Right. And I feel like what she's trying to do here is get a record of her reality from the court, because that's how she frames her worldview, is through these court records. So it needs to be in a court record for her to be consistent with it being her worldview. And courts are, I mean, they make rulings. They don't decide what's true and false. I mean, they make a ruling, right?
Yeah.
They do judgments. They judge things. And it's not like science. This is not a scientific paper that gets published in a journal, right? Like, but she has that mentality where if I can get the court to put this in the thing, then it's true. And
just like with the police reports and the medical records.
Yeah. Anyway.
Yeah.
I digress.
All right. Let's see. I think we read this part already. Okay, the consequences. Oh boy. The record before this court supports only one inference. Petitioner failed to appear without explanation. Well, it was first thing in the morning during business hours, and I don't think the judge actually said without explanation. She just said Laura Owens is not here. So that inference is false, and it forecloses the appellate review this case requires. It is also the inference respondent has been exploiting publicly. Okay. So she did not appear the first time because she was at a horse jumping show and lied about having a medical emergency. But Mike is wrong for questioning that you might be having a medical emergency the second time. Sure. He has made statements both while the restraining order was actively enforced and continuing as recently as the date of this filing, characterizing himself as a victim of petitioner, which he is. A finding no court has ever made. Oh, honey. We're getting there.
You don't have to have a court judgment to be the victim of crime, abuse.
He also maintained his innocence when he just gave in on the first when she got the original order. It's like, this has been a financial nightmare. It doesn't matter. I don't want to be near her anyways. And then he maintained his innocence when he did that. So I mean, this is kind of ridiculous. Let's see. A finding no court has ever made and implying that prior judicial findings have been vacated or reversed, which is likewise false. Prior judicial findings have been vacated. When did he say that?
I don't know. I mean, she doesn't include any source material, right? She should, if she's going to complain about a statement Mike made on a video or something, she should have the URL and the timestamp in here, but she doesn't, and the quote. Personally,
I just think she should shut up, but there's that too, I guess.
It's a lack of attention to detail.
Yeah. All right. Characterizing himself as a victim of respondent, blah, 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 which is likewise false. No prior finding has been vacated. Okay, nobody said that it was. The November 5th dismissal was purely procedural, entered without any evaluation of evidence or determination on the merits. Well, you didn't show up to do the determination on the merits, did you? The incomplete record provides no corrective account because it does not reflect the circumstances that actually produced the dismissal. Whatever. The motion to correct and augment has never been ruled upon and must be addressed. So she filed that motion to correct and augment. We talked about that above. I don't think that we need to really go through all of this here. Hang on. Okay. Yeah, I think we're good here. She's just saying she wants to augment the record to include all the stuff she was just talking about. Yeah. Preparing an adequate motion to augment requires identifying each item with a specificity, establishing provenance and authenticity. Good luck with that. And demonstrating relevance to each issue on appeal. Petitioner did not understand this to be the necessary path until legal counsel identified the record deficiency as the dispositive obstacle to representation in the weeks immediately preceding this filing.
She's learning, Lauren. She's halfway to her bar card.
God damn it. I'm going to file a bar complaint against her. Both attorneys who appeared at both attorneys who appeared at the dismissal hearing are the subjects of active state bar proceedings arising from their conduct in this litigation. So she complained to the bar about Rachel and Omar. The bar has to consider her complaint, and she's like, "This is a victory, yay!" I don't know. She's just complaining because they talked, I guess, made media statements, as lawyers often do, especially in higher profile cases. This one involves a pending 14-time felon. Possibly she'll plead down, but I believe that it's very possible that she goes to trial and a jury convicts her on all 14 of those. But this case involves somebody who is higher profile compared to most, especially family court cases. And it's not unusual for attorneys to speak to the media when the case is over. The case was over. Okay. So it's just stupid.
Also, the fact that a bar complaint has a intake number and has been assigned to the state bar council is very normal, right? They can't just look at it right away and dismiss it or do something with it or act on it, because this case, if she does have leave to file more things, right? We're just looking at this stuff, which we've seen was just filed recently. I don't think the bar can deal with bar complaints until the litigation matter is completed. So of course these things are just going to sit there. I mean,
yeah.
It's not the win.
Ms. Medusa says, "I can't believe she did a bar complaint against Rachel." I can. Rachel is a smart, hardworking, professional person who has a lot of people who love her. Laura would loathe that. In fact, the only person who would hate a woman having all those things more than Laura is David. So I can absolutely believe that.
Yeah. So, Rachel's all right.
She sucks. Prior to the November 5th hearing, petitioner filed. So you filed this before the. Oh my God. Prior to the November 5th hearing, petitioner filed California state bar complaints against both attorneys who appeared when she was dismissed. Omar Raul Serrato, not my Omar Sr. You keep him out of it, but this guy, fine. Lead counsel for respondent, who secured the dismissal and immediately moved to reserve on attorney's fees, and Rachel Elizabeth Juarez, Esquire, associated counsel. We have the same middle name. Neat. I should have known that by now, I think. Both complaints arose from conduct in connection with this litigation and were filed before the hearing occurred. So you complained about something in connection with the litigation. Okay. Next. I mean, she complains about so many attorneys, you know what I mean? Even her own attorneys. So that doesn't really mean anything to me. Arose from conduct in connection with this litigation.
What does this have to do with anything? What does this have to do with filing an appeal?
She filed a complaint against these attorneys in connection with her litigation, probably because she didn't like that they were representing the other party, as she often does. File complaints, and she made that horrible accusation against Clayton's attorney when he was Greg's lawyer.
Yeah, but I mean, why is this relevant to getting an extension to augment the record or to be allowed to file an appeal? What is the relevance of this to anything?
It's not, and that's why I was saying in the very beginning before we started reading this, I was like, I don't think she needed to do all this. This is really unnecessary. It's just for funsies. She treats her legal filings like a blog post. She's even put my picture in them before. I think yours too. So
yeah, dear diary, Rachel and Omar were mean.
Yeah, so it's normal to make and very much allowed to make a media request to record hearings. And the court, if they don't want to allow recording of that kind of hearing or streaming of that kind of a hearing, they just say no. Which is what happened to me. I put in a request to stream Mike's hearing. The family court's judge said no. And I was like, okay, well, that kind of makes sense because they probably just don't allow family court hearings like that to be recorded. I know a lot of it's very private. Sometimes family court involves minors. And so that makes sense to me. I didn't say anything to anyone about it. And then next thing I know, she's put my picture in a filing saying that I'm fundraising for Mike as retaliation against the court for denying my request. And I was like, what are you fucking talking about? Like, what is wrong with you? And like, I've been for like 2 years now, advocating for these victims and what she's done to them in court, and promoting any sort of charitable fundraising for their legal fees, because she is torturing them with the legal system. This isn't a new phenomenon for me. Okay, so I don't really know what the point of that was, but she's like, when it comes to her court filings, she's just using them to create an official record attacking people that she doesn't like. She doesn't actually care about the pursuit of, any sort of justice or any laws that may have been broken. She's just like, let me just attack everyone that I've ever disliked or has ever said anything about me that I didn't like. It's ridiculous. And her stupid attorney, David Gingras, taught her to do it. So, Jupiter James, thank you for the $5. I love you guys, and LO can suck it. No, we don't want her to do that.
That's how you get fake twins.
Right, exactly. Miss Medusa, thank you for the $5. This is just one long toddler tantrum. It really is.
I agree.
All right, I got to pick up the pace here. I got 22 minutes. So, all right.
Yeah, I got less than that.
Okay. Both complaints arose from conduct in connection with the litigation, blah, blah, blah. Both complaints have progressed beyond intake. Like, okay. Each has been assigned to a named state bar trial counsel and has required the production of specific documentary evidence in furtherance. Yeah. So that's what happened when I filed my complaint against David. That didn't mean anything. Like, they just ask you for evidence. They ask you to. So when you do a complaint to the California State Bar, you provide very minimum information. You don't attach evidence or anything like that. And then the person who gets assigned to look into that, they reach out and ask you for that kind of stuff. This is not abnormal. This is, I think, very strange representation here. The misrepresentations under investigation include public statements made by counsel. They're under investigation because you complained about them, made by counsel about the DVRO renewal proceedings. So basically, she was a Karen and she whined to the bar because the counsel made media statements on behalf of their client, a very normal thing to do. Specifically, statements about petitioner's whereabouts. Well, they were true statements. And about whether she offered or refused to provide medical verification and offer the documentary record confirms she made. I don't know what she's
I think there's a difference between, like, I have a GPS tracker and I know Lauren is at Culver's right now, and Laura didn't show up to court. Like, saying she's not at the courthouse is not talking about her whereabouts. It's talking about her where not abouts.
My God. This whole thing is so stupid. Hang on. Stir Crazy, thank you for the one gifted membership. I appreciate that. Oh, and thank you, Steve, for getting these documents for us. I think he's in the chat too.
Oh, right on.
Yeah. All right. Moving on to the stupid stuff that she's saying. The implications for this application are direct. Petitioner must prepare an appellate brief without counsel in a proceeding whose central facts are simultaneously under active state bar investigation against attorneys who are subjects of that investigation, who hold every structural advantage over an unrepresented party. Listen, this is stupid. She didn't show up. That's the issue at hand. So the bar complaints don't mean anything. Petitioner has diligently pursued appellate representation and faces documented financial hardship. We're a little shaky on the details of Laura's finances.
Oh, princess, it's so hard to be you.
Right. Petitioner's pursuit of appellate counsel has been continuous and in good faith. The written declarations she received in the weeks immediately preceding this filing from two separate sources of legal counsel, each of whom reviewed this matter substantively before concluding that the incomplete record precluded representation. And we're assuming that that's all they said, by the way, because that's what she would like us to believe. Are evidence of that diligence, not its failure. Okay, congrats. Get a lawyer. Her inability to retain private counsel is not a matter of preference. Petitioner is currently a party to bankruptcy proceeding with a hearing scheduled before the United States. Not anymore. Not anymore.
Dismissed.
Yeah. I mean, that doesn't matter. That doesn't matter because like I said, it's very normal for them to grant these things. They did grant her the extension, but she's not anymore a party to a bankruptcy proceeding. So that's stupid.
Yeah.
All right. New conduct by respondent requires investigation and may warrant independent legal relief. And here's the part that was just like really disgusting. Petitioner has identified conduct by respondent, who is Mike Marraccini, raising questions on 2 distinct legal theories, neither of which she can adequately evaluate without counsel. Your tinfoil hat theories are not legal, but okay. First, when a renewal petition is filed before an existing order's expiration, the order remains operative pending adjudication. And she's about to say something really stupid here. Petitioner filed her renewal petition on July 10th. The order, therefore, remained in force through at least November 5th. Respondent participated in public media appearances made during that period that were broadcast to a substantial national audience. Then the then active order expressly prohibited respondent from disturbing petitioner's peace, harassing her, and contacting her directly or indirectly by any means. He did not do any of those things. Literally, like I said at the very beginning of the stream, Laura should close her browser if she doesn't want to hear what people have to say.
Wait, what did he... What did he do? He
talked to people.
The Lovecraft podcast.
He talked to reporters.
I mean,
about his experience.
I didn't put him on line. Did someone else? I don't remember. Did Megan talk to him?
He did one with me right after November 5th.
Oh yeah. Well, even if they,
the complaint wasn't even operative. This again, that's not harassment, but the complaint wasn't even operative.
I mean, on November 5th. I mean, I remember talking to Omar, and I talked to Megan Fox. And I think that's it. Like, I don't remember. I don't remember anything on that day where he did a thing. He may have recorded an interview with Stephanie for the podcast, but the podcast didn't come out until well after all of this.
That doesn't matter. That came out like last week.
Yeah, exactly.
Britt wants to know what's happening. So there's a motion for attorney's fees and costs filed by Omar on behalf of Mike in the California case. And then one of the exhibits to that is this filing that Laura made asking for an extension to file her appellate brief. And in it, she really didn't need to do all this, but in it, she's writing this like huge Karen-like thing, just like saying all kinds of crazy shit. They, of course, granted the extension because that's like a normal procedural thing, but she like turned this into a Medium blog. So it's just kind of stupid. All right.
This is crazy. I guess it doesn't matter because she's going to complain about everything anyway in the next paragraph.
Oh, yeah. Okay. We're not there yet. We have to get to the other complaints first. Okay.
I know I should get through it. Oh boy.
Those recordings contain material falsehoods about petitioner directly and irreconcilably, oh my God, I can't talk, contradicted by respondent's own sworn deposition testimony of January 18th, by audio recordings in petitioner's possession, and by contemporaneous text messages in petitioner's possession reflecting respondent's own words, establishing that misrepresentations reflect not a difference in recollection but deliberate falsehood. Their broadcast foreseeably generated sustained harassment directed at petitioner. No one's harassing her. Nobody wants to talk to her. Nobody wants to be near her. We want her to go to jail for the crime she's committed, but like nobody's harassing her by talking about her public filings. Like also, when you put all this like random gossipy crap in a court filing that it doesn't need to be here, then people talk about it. It's like that's not harassment.
Yeah. There's also 2 problems with this. One is she says there's all these materially false statements, but she doesn't say what they are, and then she doesn't prove that they're materially false. Right. She just claims they're materially false.
Right.
So she fails to prove part 1. But even if she could prove part 1, it's not illegal to, I don't know, go on a podcast and lie if you really want to. I mean, I don't know. I mean, if you do and it meets the definition of defamation, then someone could file a defamation case. But if you're just, if I sit here, Lauren, and I tell you I went to Culver's yesterday and I didn't go to Culver's and I lie to you, it's not illegal.
I'm going to go to Culver's. See you later.
I know. Right?
All right. Jack says this is all about Love Trapped, and that's probably too. I think she probably really enjoyed episode 8. That was probably
I think that's some good insight there.
Yeah. All right. Second, and independently, respondent has made public statements beginning in the period immediately following the November 5th dismissal. So after this was dismissed, and continuing as recently as the date of this filing, containing the same category of deliberate falsehoods. Again, what falsehoods? Contradicted by the same deposition testimony, audio recordings, and contemporaneous text messages described above. Audio recordings, guys, are most likely screen recordings of YouTube videos distributed to a substantial national audience. The deliberate public dissemination of materially false statements about a person made repeatedly and to a national audience in a manner that foreseeably generates sustained harassment directed at that person. That didn't happen. Constitutes conduct that destroys the mental or emotional calm of the subject of that conduct within the meaning of Family Code Section 6320. California courts have held that such conduct need not occur within the context of an existing order to constitute abuse cognizable under the Domestic Violence Prevention Act. So she's calling this domestic violence. Him using his free speech rights to tell his side of the story is domestic violence.
Yeah. I mean, here's what she's doing, Lauren. She's trying to use the court system to make the universe keep her calm and placate her mood. It's perfectly rational, right? Like,
totally.
Yeah. The world owes it to me to be calm. So I'm going to use the court system to keep myself calm.
That sounds about right.
What?
Yeah. It is precisely this category of conduct that warrants the issuance of a new protective order. Determining the precise legal basis for relief and its full scope requires analysis petitioner cannot responsibly undertake without counsel. The balance of equities compels relief. Okay, we're talking about this stupid shit again. On one side, a self-represented domestic, well, it's definitely a self-representation that you're a domestic violence survivor, Laura. That's not actually me talking to Laura. I'm just thinking out loud. I don't want to talk to Laura. A self-represented domestic violence survivor whose ADA accommodation requests were denied, who suffered a life-threatening medical emergency on the morning of her hearing, who notified the court in writing before the proceeding began, whose notifications were acknowledged in writing before the matter was called. They said, "We received your email." Who submitted medical documentation and offered HIPAA verification that no one accepted, who was dismissed despite all of this, who the day before the hearing was entirely excluded from ex parte. No, you weren't. I'm like, oh my God. Again, they copied her on these emails. And that's not an ex parte communication issue. Between court staff and respondents' counsel regarding whether the hearing could legally proceed. Oh, she's using ChatGPT so hard here.
I mean, the EM dashes have been littered throughout this thing. Right?
She's using ChatGPT. I don't care. Communications that determined the outcome of that question without her knowledge or participation, who filed a formal written objection to the privately retained reporter and explicitly declined to waive her statute. By the way, she thought the privately retained reporter, as I've heard in interviews, she thought it was a JFC conspiracy reporter, court reporter. It was a JFC plant.
Is this entire thing just a string of semicolons?
I can't breathe because she's still using the same sentence.
Is this all one sentence? Look at the semicolons, Lauren.
This is like her victim resume right here. We're looking at her victim resume. It's a run-on sentence of shit that didn't happen.
She knows I don't like the semicolons. She's attacking me. She's abusing me with semicolons.
Yeah, right. The court reporter was Brad.
Oh dear.
I'm kidding. Anyways, communications that determine the outcome of that question without her knowledge or participation, who filed a formal written who filed a formal written objection to the privately retained reporter and explicitly declined to waive her statutory right to an official court reporter, a refusal that under the court's own written directive required the matter to be continued. No, she waived her right to having a court reporter. Like they had a court reporter, an official court reporter who was licensed.
Right.
And retained for the hearing. You can waive your right. You can waive, like, you don't want to have a hearing without a court reporter, but you don't get to be like, oh, that court reporter's a plant. You know what I mean? Like, that's just stupid. Who filed a motion to correct the record that was jurisdictionally stranded the following day and has never been adjudicated. Oh, jeez, I'm tired. Who diligently pursued appellate representation for months and received declinations in the weeks before her deadline that identified a correctable path forward and invited reapplication once that path is taken. That is just word salad university right there. Who faces documented financial hardship evidenced by pending bankruptcy proceeding. How's that going? Who must proceed against attorneys under active state bar investigation. It's pathetic. Can we
subpoena her ChatGPT account? I'd like to see what else is in there.
We probably should. for alleged misrepresentations about these very proceedings and who has been subjected to sustained and documented harassment as a direct and foreseeable result of respondents' public conduct. She asked for 60 days, the time that would allow her to correct the record, reapply for representation, and brief this appeal properly, which, of course, again, they granted the extension. She didn't need to do all this. That's like a normal thing to do.
The end of that sentence, time that would allow, and then listing 3 things, that's very ChatGPT to me.
Yep. On the other side, a party who publicly solicited and raised in excess of $50,000 for his legal representation in this matter from an online community whose members have directed sustained harassment at petitioner, talking about her crimes is not harassment. Yeah. Harassment that flows directly from respondent's public portrayal of himself as a victim. Again, he's allowed to tell his side of the story. A portrayal the judicial record does not support. If you look at the court records from this hearing and the disputes that were going on before it, it does support that.
See how she glosses over this by saying harassment that flows. What does flows mean? It doesn't mean anything. It's a junk word. Yeah. Like, we read the court documents and we read the evidence and the laptop that was independently forensically verified, and we make up our own minds about it. Mm-hmm. Is that what flows means?
Yes.
That's not what she wants it to mean.
Oh boy. Okay. Respondent stipulated to the original domestic violence restraining order in 2018 rather than contest it. The San Francisco Superior Court granted the renewal on the merits. No. Okay. They granted the renewal because the law in California is so lax that even like if she's saying they're like, well, I'm afraid, they'll renew it. The order remained in force for 7 years. Respondent has nonetheless made public statements, as he's allowed to. He's allowed to talk, contradicted by his own sworn deposition testimony of January 2018, by audio recordings in petitioner's possession, and by contemporaneous text messages reflecting his own. Now she's just copy pasting. Okay. In which he portrays himself as the aggrieved party and implies that prior judicial findings have been vacated or reversed. He never said that. Neither is true. No prior finding has been vacated. The public campaign... God, this again.
This is crazy.
This is so Blake Lively coded. The public campaign built on those misrepresentations has generated the sustained harassment petitioner now faces, financed in part by the same community that funded respondents' legal representation in these proceedings. Nobody's financing a campaign against you. That's stupid. And also, people are allowed to fundraise for legal fees. Respondent enters this appeal fully funded, fully represented, and facing no cognizable prejudice from a 60-day extension of time. Literally, neither of these things is true. He's not fully funded. His legal fees are double what he was able to raise, and that's with like Omar seriously like down, adjusted his fees to try to make it more feasible, and it was still over $100,000. And Mike raised $50K. So Mike does not have any money left from that fundraiser. And also, Omar's not an appellate attorney. So he's probably going to have to find another attorney who's going to be a lot more expensive.
Oh yeah, how is he?
I don't know for sure what's going on there, but I'm just saying Omar's not an appellate lawyer, so I don't know if he's going to be able to do it.
Lauren, I have to go. I have to get ready for my next gig. So
yeah, get out. I'll see you later.
You guys are great. Thanks so much. Talk to you later.
Bye. All right, I'm going to finish this little Karen rant here, and then I have to go back to work. I have a few more minutes. But the end of this is probably the worst part, actually. So, all right. So she's alleging sustained harassment because people talk about how she lied, basically. Let's see. Respondent enters this appeal fully funded, fully represented, facing no prejudice from a 60-day extension of time. The 2018 restraining order, which respondent stipulated to rather than contest, was supported by a sworn declaration from Karen Ilmberger. That's the napkin lady. A complete stranger to both parties. Well, she's in my opinion, she's fictional. So she's a stranger to everyone. Seated directly in front of them on their December 30th, 2016 flight to Iceland. Ugh, what just happened to me? Iceland. Okay. Miss Ilmberger declared under oath that respondent was emotionally and verbally abusing Miss Owens for a long time, that he was so menacing that I felt her life was at stake, where to stay with him, and that she was so frightened of respondent that she omitted her own name from the note she passed. How the fuck did you find her? From the note she passed the petitioner because she was afraid that he would come after me if he found the note. That account from a disinterested witness who had never met either party has never been challenged in any court. Respondent stipulated to the order it supported in 2018, contested the 2020 renewal and lost, and the order stood for 7 years. So that declaration was something that Laura's attorneys at the time wrote up Karen, napkin lady, signed off on it. And then it was presented to the court. She never testified. No one has ever seen that she exists. And I would seriously implore everyone to, use their judgment and deciding whether or not you believe that this person exists and that it actually happened the way that she tells that it happened, because this is somebody who in a criminal investigation has now been found to have faked a physician's note. Like, we all know that she's faked doctor's notes before, but it's never been proven in a criminal investigation before. We now know that one of the physician that she faked a note from has said to criminal investigators, no, I did not write this note, and said that she would help them in their case, that she would be willing to assist. So she probably signed that declaration herself. Just saying. All right. I don't think Napkin Lady is real. I don't think Napkin Lady is real either at this point. I used to think that she was a real person who just didn't know what was going on. But like, Mike went and hid in the bathroom for part of that flight because Laura ambushed him. Like, Laura was not supposed to be there. He thought he was going by himself, and she ambushes him, surprises him, and is sitting next to him, torturing him the entire flight, crying hysterically. And people are having to be like, yo, what's going on here? And he couldn't calm her down, and he couldn't get away from her. There was nowhere else for him to sit. So he had to hide from her in the bathroom. And I'm supposed to believe that some magical napkin lady thought that he was so abusive that she passed a secret note to Laura, and Laura somehow tracked her down, even though she didn't want Laura to know who she was. Okay. That's neat. That's a neat story. All right. Okay. That account from a disinterested witness who had never met either party has never been challenged in any court. Well, it couldn't be challenged because you didn't show up. She didn't show up to her court hearing. Respondent stipulated to the order it supported in 2018, contested the 2020 renewal and lost, and the order stood for 7 years. The Domestic Violence Prevention Act was enacted to prevent acts of domestic violence and their recurrence. And it's very gross of Laura to have exploited that. Its provisions are construed liberally in favor of protection. Denying this application would forfeit, through procedural attrition, the appellate rights of a petitioner whose absence was caused by a documented medical emergency acknowledged by the court itself, whose motion to correct the record was never ruled upon, and whose inability to meet the current deadline flows entirely from circumstances beyond her control. That outcome is inconsistent with every purpose the act was enacted to serve. Everything Laura Owens has done against her victims in court, Mike Marraccini, Greg Gillespie, Clayton Eckerd, is against the spirit of what a Domestic Violence Prevention Act is supposed to serve. So that's pathetic. Okay. For the foregoing reason, petitioner respectfully requests that this court grant a 60-day extension to file the brief, which they granted, accept this application as timely, okay, and grant such order, other and further relief, okay? And here's the really infuriating part. She says, petitioner hereby advises this court and places respondent on formal notice. So she's placing Mike on notice that independent of the outcome of this application, she intends to seek a new domestic violence protective order arising from respondent's recent and ongoing conduct, which includes using his free speech to tell his story. If I were Mike and I had to fight that, I would hit her with a huge anti-SLAPP suit. But then again, that's expensive, so maybe he won't. Petitioner hereby advises the court and places respondent on notice that independent of the outcome. So she's appealing the overturning of this DVRO, but then she intends to file a new one regardless of whether or not it happens here. Like, that's fucking nuts. It's fucking nuts. This poor guy and his family, his two daughters are being tortured by this woman. Mike is a really wonderful man. If you haven't had the chance to meet him, maybe someday you will. And I would definitely say he deserves every bit of support that people can offer him. Danielle, his wife, is also a really wonderful person. He has a great family, and they all deserve peace. He just wants her to leave him alone. He just wants her to not be in his life, and she won't stop. She will not stop trying to drag this man back through courts because she won't have to pay a dime. She can keep abusing the courts against him and won't have to pay a dime, and he has to ruin himself financially to pay for lawyers. Otherwise, she just gets to do the same thing she got to do back to him in 2018. due to him back in 2018. This is insane. So, Britt says, shout out to all the survivors who have similarly hidden bathrooms for safety. Right? Right. Like, she ambushed him on that flight when he was just trying to get away from her. He did not want to be with her. And she just showed up on a flight that was full. So he had nowhere else to go and he had to hide in the bathroom. And she got an order against him. It's fucking nuts. I feel so bad for him. Mike has definitely been through it, probably. And it's probably not over, unfortunately. So, yeah. So she doesn't have to file her opening brief, I guess, until June 27th now. But even this is like, she didn't have to do all this. She didn't have to write all this in here. She just loves a drama. So, you know. Of course, we'll continue to try to help Mike. I think there's a link to his GoFundMe. Hang on. Let me see if I can find it. Because this shit is just going to cost him a lot of money. Just give me 1 second here. Yeah, here's the link to Mike Marraccini's GoFundMe. I'm going to pin it here in chat. Oh my God, it won't let me. Hang on. It's too long. It says the link is too long. No. I think I can fix this. Hang on. There we go. That's better. All right, I'm going to pin it here. And then I'll pin it to the top of chat when this is over because I got to get back to work. So, all right. Okay, guys, that's the end of that. So there's a lot more to this. As you can see, I'm looking at a 214-page document, and this is just the exhibits that were filed with the motion for attorney's fees and costs. So I'm going to come back tonight at 8:30, probably Eastern, 8:30 Eastern, 9 o'clock, and we'll talk about that some more when I'm not rushed to get back to work. So, hey, Amber, what's up? Unfortunately, you came in just at the end, but hi, how are you doing? All right. Thanks, everyone. I appreciate you being here. And please support Mike if you can. We'll have lots more to talk about later tonight. All right. That's it for me now. Bye.